Hi, everyone. Harry here to talk about a mini flurry of orders by Judge Aileen Cannon in the Mar-a-Lago litigation. She did three things. The one that's received the most attention is a rebuff of the Department of Justice. The Department of Justice proffered a list of 84 witnesses. They asked that it be kept under seal. And they also asked that the Trump defense team be required to acknowledge receipt and an order that the magistrate judge had issued saying they can't talk to the various witnesses. Cannon denied that motion, and with the bad bruising experience of her in the misadventure with Trump before, everyone immediately was thinking, is this the bad Aileen Cannon re-emerging? And my take on that is no. It's a fairly straightforward thing she did, all part of the preliminary treatment of a criminal case that is actually something she does know a little bit about. She's had 4 criminal cases. They are not nearly as complex as this, but they start out with similar sort of steps, one in front of the other. So what she's saying, if you read her, it's not even an opinion. It's what's called a minute order. It's a few sentences entry on an overall docket sheet. It says, United States, you haven't shown me yet that it needs to be sealed. I need some more reasons. There are, and by the way, a consortium of media folks had also lobbed a motion in saying, we want to know the names of these people, huge public interest, et cetera. And there is a general presumption in favor of opening up or having court proceedings be public. So she said, look, I need more. From what you've given me, I'm not in a position to actually grant your motion, so I deny it without prejudice. Legal speak for saying you can bring it again. There's no problem with bringing it again, but right now there's not enough. And likewise, she said, I just don't get this idea of making Trump acknowledge, the order is from the magistrate judge is the order. Doesn't have to, in addition, heal. And there is, both sides understand, a hovering point in the background, which is Trump, a nasty one, wants to use information to fundraise and to campaign. But that has a kind of First Amendment overtone. So she's being somewhat careful about just saying, double belting and suspendering this order. It is what it is. That struck me, if you look at it carefully, as really, no big deal. And in particular, on the first point, it's true. The U.S. didn't really give her enough to seal it. Okay, so that's one. Second, the department, as part of its request for a trial date in December, which sounds like a delay, but I've suggested is really the opposite. It's they're drawing a line and trying to have it hold. They laid out a whole timeline, and it ends with let's go to trial in December. And the real important sort of guts of what happens between now and trial is litigation over classified documents, which can be detailed, time-consuming, wordsmithing back and forth. But it's something that a judge can make fairly quick work of. You make sure that the defense have security clearances to look at these documents. Then there's a question of how to redact them so a jury can see them. There'll be fights on this, of course, but Cannon should be in a position to adjudicate those fights and quickly, and that's the really core point in the DOJ requested schedule, which says we can handle all of this by early December and then start trial. And this is there are other things, of course, we know that Trump is going to be doing, like a motion to dismiss for prosecutorial misconduct, maybe a motion to revisit the crime fraud exception application of his lawyer Evan Corcoran's comments that actually might come closer to trial. But there's a date set for those pretrial motions, and it's soon, so they've got to bring them. And it really is the if you think that Trump's main strategy is to try to delay, the classified stuff is his best way to try to do it. And so they've set that date. And the second thing that Cannon did, and I think it's auspicious. Again, it doesn't mean she's totally focused on the DOJ position, but she's doing the early conventional moves in a district that's known for moving cases along quickly. She said she set a hearing for July 14th, as requested by the DOJ, to get the sort of ducks in a row on how they're going to handle classified procedures. So if that hearing lays out a pretty methodical schedule, let's say it gives a little and it's into January, whatever, it's going to make it much, much harder for Trump to try to, use that in like silly putty without breaking it to make it go to not just February, March, but August, September, which is what he really wants. And then finally, and along those lines, the third order says you have Team Trump until July 6th to respond to the DOJ's proposed schedule, which I've suggested DOJ is really pretty smart to do. There's this, whole phenomenon in social sciences, negotiation, et cetera, called anchoring, and you name. There's a lot of we're far afield, but I think it actually is pertinent. How when you negotiate for a price, should you give the first price? Should someone else? Should you wait for the other person to do it? And an argument for doing it is this so-called anchoring idea, which now the date in people's minds is December 11th or whatever the DOJ said in December, and that just means January, even February sounds in the ballpark, but if they come out of the box, as they might have had they been first with, the earliest we could possibly do it is next August, they're going to look like they're being really dilatory, and just trying to stall. So a lot's coming up soon, right? We have they have to respond by July 6th. And then we have a hearing on classified stuff July 14th. So, the preliminary parts of this trial are moving along with some dispatch. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.